Okay, good morning, everyone. I'd like to thank the Ono Academic College and the World Intellectual Property Organization for inviting me here to share my thoughts about traditional knowledge, protecting traditional knowledge, why we should protect traditional knowledge, who the possible beneficiaries of protection may be, and the issues related to the commercial exploitation of traditional knowledge. Some of my comments resonate or follow from the previous speakers, so there might be some repetition, but repetition is good sometimes, so things can stick. I just want to talk briefly about the history of this whole issue of protection of traditional knowledge, which really dates back to the 1970s, when initially we weren't talking about traditional knowledge then. Actually, we were talking about the unpublished works of unknown authors. Actually, thereafter, in the 1970s, the international community proposed what is referred to as the Tunis model, which really was copyright law. And within that copyright framework, folklore was recognized as a category of works to be protected along with literary and artistic works. Thereafter, the discourse transformed, or maybe it was refined, some say, and a distinction developed between what we refer to as traditional cultural expressions, referring to the artistic subject matter, and traditional knowledge, referring to the more technical or scientific subject matter. And based on these two major categories of subject matter, traditional cultural expressions on the one hand, and traditional knowledge on the other, we see two what are referred to now as draft articles emerging out of WIPO's IGC, and I believe Vend will be referring to those draft articles in his response to my paper. I will be referring to these draft articles as well from time to time in different parts of my paper, which I can make available to you all if you wish. Through the organizers, of course. So after that brief introduction regarding how we've come to this place where we have draft articles that look at, on the one hand, protecting traditional cultural expressions, and on the other, traditional knowledge, I want to go into why we protect traditional knowledge and some of the arguments that have been formulating or can be gleaned from the literature. And I have to say that this area can benefit from more academic consideration. Certainly, why we protect traditional knowledge has not been given the kind of dedicated academic treatment as we have looked at why we protect intellectual property, for example. And intellectual property justifications have emerged over decades, and they include the economic incentive argument, the labor theory argument, and the personality theory. Traditional knowledge, the literature I've read about traditional knowledge, sometimes protection is almost taken for granted. Yes, of course we should protect it, but in terms of why we should protect it, I think the focus tends to be on how we protect it as opposed to why we protect it. But some authors have started to look at the issue of why we protect traditional knowledge. Graham Dutfield, Professor Dutfield is one of those authors, and I refer to his work. Professor Shiva as well also looks at why. And I'm proposing these following arguments that can be used in relation to the protection of traditional knowledge, and I'm using the word traditional knowledge in a very broad and general sense to include literary and artistic subject matter and scientific and technical subject matter for the purposes of my paper. Okay, so these are some of the arguments. The protection of cultural identity or the preservation of cultural diversity, that's one reason why we should protect traditional knowledge, because protection of traditional knowledge can lead to the protection of cultural identity or the preservation of cultural diversity. And I will go into that a bit more. There's also the equitable sharing of benefits argument. That's one of the reasons why we should protect of traditional knowledge because it promotes a more equitable division of the benefits of the owners of traditional knowledge and the users of traditional knowledge, and that was alluded to by the previous speakers. There is the respect and parity argument that we should treat traditional knowledge in the same way as we treat other forms of knowledge that are subject to intellectual property rights and intellectual property protection. And there's the quality of life argument that protecting traditional knowledge, particularly of less economically wealthy communities, can lead to the improvement of the quality of life of those communities. Okay? Let's go back to the first one, the protection of cultural identity or the preservation of cultural diversity argument. This argument for the protection of traditional knowledge, more so than some of the others, is directly linked to how we define traditional knowledge. Traditional knowledge is usually defined as being associated with a particular group, and that knowledge usually is characterized as being representative of the cultural identity of that particular group. So by protecting knowledge of a group that is associated with its cultural identity, that would lead to the preservation of their cultural identity, as at least that's how the argument goes. Right, the equitable sharing of benefits argument. There's a widely held belief that traditional knowledge is vulnerable to commercial and other forms of exploitation by those external to the source community. And again, the previous speaker referred to the Madagascar situation, the periwinkle plant in Madagascar. And this fuels demands for the protection of such knowledge that respects and responds to its particular characteristics and to the needs of the holders or custodians of such knowledge. Traditional knowledge holders have asserted that they should benefit from earnings resulting from the commercial use of their knowledge and have advocated for a regime of protection that includes a system of equitable benefit sharing. Now, although the idea of equitable benefit sharing emphasizes fairness in the distribution of resulting benefits, many who advocate the protection of traditional knowledge are equally concerned with matters of procedural fairness, in particular that the source community is given the right to determine whether and in what manner traditional knowledge can be used. And as a result of this, we have what we refer to as prior informed consent provisions in the draft articles that are under consideration by WIPO, and there are also prior informed consent provisions in the Convention on Biological Diversity and the Nagoya Protocol to that convention that makes extensive references to the need for prior informed consent and how that prior informed consent of source communities can be obtained. The forerunner to the Nagoya Protocol, the Bonn Guidelines, also details procedural protocols that one may follow when an external party wants to access the knowledge of a particular community. Okay, then we move on to the respect and parity argument. The argument has been made that traditional knowledge should be protected to give it parity with other forms of knowledge, which attract protection via a well-established system of intellectual property rights. The promotion of respect forms part of the stated objectives of the protection of traditional cultural expressions in the draft TCE's articles that you all will be receiving through VENT. And also, I believe in the draft TK articles, but I think those will follow. Yeah. Some academics believe that initiatives to recognize rights to traditional knowledge within the national and transnational context really concern power relations played out in the contest for ownership and control of resources between communities and states, between developing and developed nations, between North and South. Others, like Vandana Shiva, believe that the initiatives to protect traditional knowledge are reflective of efforts to reverse or address the effects of colonialism on traditional knowledge. and recognize different knowledge systems. So there's no hierarchy of one knowledge system over the other. So they're treated more or less equally. And then there's a quality of life argument, as I mentioned before. The quality of life argument suggests that traditional knowledge should be protected because such knowledge can contribute to the improvement of the quality of life for the communities from which such knowledge originated. According to Professor Dutfield, traditional knowledge is valuable first and foremost to indigenous and local communities that depend on such knowledge for health, livelihoods, and general well-being. Therefore, a traditional knowledge regime that encourages the conservation and continued use of traditional knowledge relating to health and food production, for example, could potentially improve the lives of millions. Dutfield also refers to traditional low-input agricultural systems based on extensive and applied knowledge about natural processes and local ecosystems, which have successfully enabled millions of people to subsist for thousands of years in some of the most hostile environments. And now recently I came across a publication by the World Bank. It's a 2012 publication, and it's looking at ways of approaching intellectual property protection and grounding intellectual property protection on a human development perspective. And when I read that, although it was a discussion in relation to intellectual property, I think there are lessons for looking at protecting traditional knowledge, especially if we're attempting to theorize the protection of traditional knowledge. And this whole notion of human development, more so community development, can be useful in terms of thinking about why we protect traditional knowledge, because it is heavily group and community oriented. Now, there are other arguments in terms of the protection of traditional knowledge, but related to genetic resources and the conservation of biological diversity. And I'll just mention those briefly. So we can say that to protect traditional knowledge associated with genetic resources means that we can prevent what is referred to as biopiracy. And that would also relate to the preservation of biological diversity. But those justifications are with respect to a specific category of traditional knowledge. Okay. I just want to talk briefly about the whole issue of ownership and beneficiaries of protection. I want to say a few words about the ownership concept in relation to traditional knowledge protection. And I know in the past that using ownership in relation, the term ownership in relation to traditional knowledge was met with some reservation in terms of indigenous and traditional communities, because the concept of ownership didn't carry with it or didn't convey with it a sense of responsibility to preserve that knowledge. Once you own something, absolutely, you can do whatever you want with it. So words like custodianship and stewardship were at times preferred words used in relation to, or preferred terms used in relation to indigenous knowledge and traditional knowledge. But I notice in the deliberations, the recent deliberations at WIPO, that ownership is used quite liberally. And as a matter of fact, it's actually preferred by some member states, because with it, there's a belief that you can exercise positive rights once you own something, as opposed to negative rights. So I guess it's a double-edged sword. Once ownership comes with some level of responsibility in terms of traditional knowledge, a responsibility to preserve it and pass it on, well, then that could probably negate some of the concerns regarding its possible abuse. The other thing I want to mention is the diversity of beneficiaries, which is recognized by the draft articles under consideration by WIPO. The beneficiaries of protection are diverse. They could be groups considered to be indigenous, as that term is understood in international conventions and international discourse, or traditional, or cultural, or even religious. There is an argument that countries can be possible beneficiaries of traditional knowledge protection. In the Caribbean, where I'm from, there are a variety of possible beneficiaries of protection for traditional knowledge. In my country, Trinidad and Tobago, there is our national instrument, the steel pan, which is an important cultural signifier for us. And if we want to frame any rights in relation to the steel pan, it can only be a right that can be attributed to the country. There's no particular group per se that can claim rights to the steel pan as opposed to or versus the country. So it would be a state right, a national right. And I know there are discussions to that effect going on now at WIPO. Okay, I'm going to wrap up. I just want to end with some brief comments about the commercialization of traditional knowledge. And there are two reports. I mean, I try to get information on the value of what are the figures we're talking about in terms of economic benefits that can accrue to the commercial exploitation of traditional knowledge. And one report referred to by Professor Graham Dutfield is a study done by a biochemist, Norman Farnsworth. And it was estimated that the value of plant-based medicine sold in the OECD countries in 1990, so this is a pretty old report, was $61 billion. And and the biochemist Norman Farnsworth estimated that of the 119 plant-based compounds used in medicine worldwide, 74% had the same or related uses as medicinal plants from which they were derived. Many of the pharmaceutical companies, according to Farnsworth, were likely to have used traditional knowledge leads in their product development. Another author suggests that of the 120 active compounds derived from plants that are widely used in contemporary medicines, 75% were already known within traditional knowledge systems. And using those knowledge systems increases 400-fold the ability to locate plants that have specific medicinal uses, according to Shiva. According to another estimate, bioprospectors can increase the success rate of their trials for useful substances from 1 in 10,000 samples to 1 in 2. So you can see a lot of costs can be reduced. Research R&D costs can be reduced if you have actual leads in terms of the values to which a particular plant can be put. In the scenarios referred to above, little or no financial benefits from the exploitation of traditional knowledge will accrue to the source communities. An author, McLeod, refers to a UN report that estimates that $500 billion annually goes unpaid in lost, royalties that could otherwise be accrued to indigenous communities, indigenous and traditional communities. Having said that, not all communities want to commercialize their knowledge. There may be sacred and religious aspects of their knowledge that they prefer to keep out of the commercial and market domain. So on the one hand, there are possibilities to reap economic rewards. On the other hand, there might be a preference to preserve the cultural and religious aspects of traditional knowledge. And I will end here, and thank you very much.